Hello and welcome to our Ask the FERPA Professor webinar. We're glad you're able to join us today. We're joined by LeRoy Rooker and Helen Garrett today. If you are new to FERPA webinars, welcome. If you've attended some of our previous sessions, we're glad you're able to join us again today. Just really quick before we get started, if you haven't turned on closed captions, you're welcome to do so. And our webinar is being recorded, and the recording will be available 24 hours from airing. I will also drop a link in the chat for you to be able to access it as well. And last but not least, we welcome all of your questions. Please feel free to drop those in the chat feature. You can post it at any time, and Helen will be monitoring those questions. And without any further ado, I'd like to hand it over to Helen. Thanks, Helen.
Yeah, thank you so much, Mama. Hi, everybody. Thanks for joining us. We love doing these 4 times a year. Let me go ahead. If you have not met the esteemed LeRoy Rooker, a longtime expert on the Federal Educational Rights and Privacy Act, FERPA, I'll let you, with LeRoy, so hello, I'll let you give his current title and his station, but he is well known and an expert inside and out as a longtime employee of the Department of Education before joining the American Association of Collegiate Registrar Admissions Officers. So he's here to provide the letter of the law interpretation to your questions, and quite often I'll come in behind as a fellow university registrar at the University of Washington to kind of contextualize it. But LeRoy, if you want to say hello and whatever your current title is and what you've been doing.
It's great to be here again. But yeah, senior fellow emeritus.
There you go.
With that at AACRAO. So love doing these and campus training and those things. So I'm still doing those.
Great. So here's what's going to happen. I'll have to try to keep track of both the Q&A and the chat, unless we want to just all stay in the Q&A. That might be easier. What we know is this hour is going to fly by, and we'll probably only get to answering questions about 10 minutes after the hour. We've got just 2 things we want to start with. But you will see me post out here my direct email address at the University of Washington. I encourage you that if you didn't get your question answered, please write to me and I will get back to all your questions afterwards. So I'm going to pose a question to LeRoy, and then I've got a question just to kind of get the conversation started, although I do see that 4 of you have posted something and we'll go to you next. So LeRoy, in light of the transition for the president on Monday, I have been getting a lot of questions from around the country of, will the Department of Education go away? And if it does, will there be no more FERPA?
So, yeah, the short answer to that and the long answer is no. It won't go away. It would take an act of Congress to eliminate the Department of Education. Now, can functions be transferred? Absolutely. So there doesn't mean that there wouldn't be any changes, but the term of elimination of the Department of Education is not one that is going to be, it would require again, an act of Congress. The Department of Education was created in by the splitting out of the Department of Education from the old HEW, Health, Education, and Welfare Department, and made a separate department in 1976, I believe it was, under Jimmy Carter. But that required legislation to split it off and make it a department. It would require legislation to eliminate it.
Yep. So we had our 50th anniversary last year of FERPA, and as far as we're concerned, it's not going anywhere. So let's not put any energy into that and keep your questions and your compliance going. I have a question. I always like to give a softball to LeRoy to get started. And again, I see your questions here, so we'll get to those right afterwards. At my institution, you are admitted to the university. You're defined as a student at the point of admission, which is odd. And so FERPA covers all your educational records because you're a student. but our students have to apply to get into restricted majors. And we are overrun with students asking us to provide their information on their application to these majors within an undergraduate program. The question constantly comes up, if they were denied into getting into computer science, but they're a UW student, what are the rules about what we have to or not provide to them?
Right. So from FERPA standpoint, records on an applicant are not education records unless the applicant becomes a student and you continue to maintain those records. Then those become education records. Same thing if you have a program, say a law school or a particular program, medical school, what have you, that takes a separate application to be admitted. Those are not education records, again, unless that student is accepted into that program. So if you have a student who was denied, who applied for, but was denied admission to your law school at UW, for example, then, and they requested their application records, that would be up to the university whether they wanted to provide those or not. You would not be required to, because under FERPA, they're not education records.
That's right. And at our state of Washington, we have a very intense Public Records Act. So they would be under the Public Records Act, but there would not be the 45-day responsibility to get back to the student, and all different rules apply. So just make sure you're checking in with your state and being sensitive to the difference between public records and FERPA protected records.
Yeah, and that's an important piece too, Helen, in that you can have state law that affords greater protection or greater rights than FERPA. You can't have a state law that undermines those. So in your case, that would be afford greater rights than FERPA would under your state open records, and that's fine.
Yep. Okay, so LeRoy, I'm going to summarize this first question that we get every time, so it's a good one. It has to do with a person who is trying to uphold FERPA with high school dual enrolled students. This person absolutely knows that once a student has enrolled at an institution of higher education, FERPA rights leave from the parents to the student, regardless of age. This person is getting a lot of pushback that since the students are under 18, their dependence on the parents, and it doesn't matter if the consent has been withdrawn from the student to share information. So the person says, am I on the right track? Is there an argument since it's assumed that they are dependent? So is there anything with high school dual enrolled students where the dependency on the parents would override FERPA rights covering the student, and therefore you can't share it with the student unless you have permission from the student?
Right. So there's an exception ordinarily to share it, because what you said is correct, that the student, once they attend a post-secondary institution, the rights at that post-secondary institution belong to the student. Doesn't matter the student's age. So you might have a 16-year-old who's taken a class. Those rights have transferred to the student at the post-secondary institution, not at the secondary institution, but at the post-secondary institution. So once they've transferred, how would you give parents access to those? Two ways. One is a consent from the student, 99.30 signed consent. So if the student agrees to that through a signed consent, then you could give them access. The other is the exception for, in 9931, the exception for dependent student. And a dependent student is a defined term under FERPA, and it's linked to the IRS tax code. It means the student is claimed on the parent's tax return. But you would need to know that in order, you cannot assume that because the probability is a high one that they are, but without knowing that, you aren't protected in that regard.
Perfect. And Kristen, you asked a really good follow-up. Am I correct that we cannot require those students to provide parental consent? You cannot force a student to provide consent. That's a voluntary. Kristen, I would offer to help you with some language back based on what we've said. If you want to email me again at Helen BG, like Helen Boyd Girl at uw.edu, to help you stand behind why they are incorrect about the dependents. But great question. This next one's a simple one. If we have a FERPA authorization form, can we deny power of attorney forms and ask that they complete our form?
Absolutely. One thing to keep in mind, and this is more overarching, but it applies, is that disclosures under FERPA to any party except the student is permissible, not required. And that includes with assigned consent. So, and that would include with a power of attorney. You can require the student to provide that consent, but it's still up to you whether you provide that. You're not required to provide it even with a consent.
Yep. And I'll just say at the University of Washington, power of attorneys mean nothing to me. I'm not going to talk to those parents at all. I will communicate out to the student and ask them to fill out our records release where they have to log in with their confidential information to make a request to share something. Okay, I was hoping this next question was going to come up, and it did. It's sad, but it did. What is the responsibility of an institution to release or to not release educational records to a law enforcement agency such as Immigration and Customs Enforcement, ICE? What are we required to disclose and in what time frame?
Yeah, so this is a beyond FERPA question, and it's one we are actually dealing with here at AACRAO. Even on this very day, we're working on guidance to get out to institutions, but essentially where that's going to go and what we're looking at is what does AACRAO, which is the statute that deals with immigration, what does that require versus what is what's permissible thing. So if and essentially what's going to come down to is if the immigration law apply, or when it does apply, so whatever is required under that immigration law is what you would disclose. If it's not required, then FERPA kicks in. But AACRAO was enacted after FERPA. The way that the executive branch views legislation that it might appear to be in conflict is that the later enacted statute is the one that would govern. And in this case, the statute that encompasses ICE and their authorities was a much later enacted statute. And so that's the one that you would look at. What does that require? And then if it doesn't require it, but you get requests, then you look at FERPA.
So it sounds like our members should really be paying attention to information coming out from AACRAO this week about what to do if they descend upon your campus and want you to turn information over.
Yeah, and it's more going to be here's what the law what's required under AACRAO. And then so we're looking at that to provide that information. But again, it's not a law that we are involved with, like FERPA, for example, but we will contrast it with FERPA, and that this is what you would look at if you don't, if it's something beyond what's required under the AACRAO, then you would look to FERPA then to determine whether you could disclose something.
Right. This is a really good time for each and every one of you to go look at your institutional's educational FERPA policy that you are to surface to your students at least annually. How do you define directory information at your institution, meaning that which can but doesn't have to be shared if the student has not opted out? Do you have a secure opt-out process? And being really careful to make sure that individuals on your campus, if they cannot see that someone has opted out of directory information, they should give out no information because they don't know that that hasn't been blocked. There's a question here, LeRoy, if your institution has a large population of DACA students, is it more helpful for them to have a FERPA confidentiality on their record?
Not particularly, because again, you're not disclosing information on them under directory information or even under FERPA, where the requirement would be to disclose information would have to come from our IRA and ICE.
Right. And so one of the steps that I'm very proud that we've done forever at the University of Washington that your institution may not have done is that we are not tracking on these data points that outside individuals might want to see. So we have a Washington student financial aid form for people who might qualify that don't have citizenship, but we can't run numbers. We can't tell you who these students are. And we did that on purpose to prevent anything in this circumstance. It's very murky with directory information versus what might be a law that someone might be able to legally require access. So I would not try to go it alone in these next coming years without legal counsel of some kind directing you through, because you don't want to do anything that's going to inadvertently hurt your students, but you also don't want to be out of compliance. I was working at a community college during 9/11. We had a lot of students from Saudi Arabia in our flight program, and the immigration descended upon our campus the day after, insisting that we provide all their records. And my president was a lawyer, and she said no, not without a subpoena. So there are things that can happen, but just don't try to go it on your own. You've got resources in AACRAO, you've got LeRoy. But mostly make sure you have strong legal counsel before taking any steps in this area, because it's new and it's sensitive. So good question.
That will be the last piece of advice from AACRAO is if you're undecided or have questions on any of this, you need to check with your legal counsel.
Absolutely.
That's
Yep.
the bottom line.
Yep. Anybody can show up to your front counter with a badge. They could have bought it at the local Goodwill store. Just because you work for the federal government, you don't get to have educational records. There are still processes or releases that have to be in place. So it's not a time to be bullied. And even with student information, you have 45 days to get back to the student, but you've got some time to carefully make a decision. There's never an emergency where you have to give out information. If there's a health and safety emergency, there are clauses within FERPA to protect you if you gave information to remediate a health or safety emergency. But the most important thing is don't react and don't go it alone. So thank you for that good question. Okay, we have high school counselors asking for names of students from their high school that have been admitted to our university. We consider the first day of classes as their date of first enrolled for FERPA purposes. What are we allowed to share with them?
So if you have that designation that the first day of class is when they become a student, then prior to that, you could disclose any information from the application and the fact that you are going to accept that student or that applicant as a student beginning in the school year, for example. So that information in the application, any of that prior to their becoming a student is not going to be subject to FERPA. Once they become a student, then it is, but it's possible even then to give out information under directory information that, previous school attended, name, those kinds of things could be directory information. They'd have to be at your institution to use that. But if they were, then you could say, you could pull out the students that went to La Brea High School and tell them who they are, as long as they haven't opted out of direct information.
Exactly. So make sure you know what your FERPA directory information says. And so this is definitely not a must. And the one thing I always like to say to new folks to FERPA, FERPA is agnostic. It matters not how good or how evil the request. It's all just what does the law allow. So it's always best to go back to the letter of the law, and we can help you through that if you have questions. If we have a student enrolled in an internship as required by a degree program, and that student is dismissed due to a violation of student conduct for criminal reasons or not, is it a violation of FERPA to tell their internship supervisor if that supervisor is not a school employee? Oh, good question.
So if I'm understanding this, it is the student is on a school-sponsored internship. They are dismissing the student. And can they tell the internship why the student was dismissed? So it's one of those, it depends. So it depends on what agreement that student has signed in order to have the internship. When I'm on campuses doing training and this question comes up, I always encourage the institution to include in their agreements with any of these for any of these internships that they're in which they have the agreement, make sure that the student is signing something that says you can disclose any pertinent information to that party providing the internship, so that you don't have to wonder, can I give them how the student's doing in other areas, that to just think that through and create the agreement in that fashion. And that's not one that that's not a signed consent per se. That's a agreement to participate in this particular internship. And you can disclose information as long as you've got it in the agreement. You could disclose that kind of information. If not, then you just have to deal with it from the standpoint of you could say that student's no longer attending your institution if you have again dates of attendance and the fact that whether they're attending or not. You could say, you just can't say why they're not. That could not be a director information item.
There's an important word that is in your question, Angela, that I want to highlight for everyone. People often misinterpret that a school employee, a school official has to be an employee of your institution, and that's not the case. You defined who the school officials are, and that should be in your institutional FERPA policy, and everyone should know. But it could be a volunteer on a scholarship committee. We have a lot of outplacement with the medical school here at the university. I work with the coordinators for these internships to do exactly what LeRoy said. So we deem the internship coordinators school officials. They're not paid by us. They're not on our books, but they are school officials because they're participating in the student's educational experience as required by the degree, and they have a need to know. But we make sure the students understand before anything goes south what the rules of engagement are. So please make a note to go look at how you define school official in your institutional policy, and to folks, it does not mean that you are paid by the institution. It means that you are doing work on or behalf of the institution and have been designated a school official. National Student Clearinghouse is a school official for all of us, for example, right? And they're not employees. So focus on that word there. That was a great question. Our email messages that refer to a particular student and are maintained in the university email system considered education records. Does the answer depend on whether the messages are stored in mailbox folders specifically identified for the correspondent with that student versus being stored in the university's official inbox and sent mail folders? Excellent question, Doug. One we get every time. So glad you asked it.
Yeah. So if this one goes back to the definition of an education record. The key definition in FERPA is it directly related to the student and maintained by the institution or party acting for the institution. That's what you would look at. So, and FERPA is technology neutral. FERPA doesn't focus on what technology you use, how you do it, where you store it, any of those kinds of things. It focuses on, is it directly related? The student doesn't meet the definition. So in this case, it really wouldn't matter if it's directly related to a particular student.
Yep.
It would be an education record.
I would write this on the wall in your office. An education record is that which is directly related to a student and maintained by an institution. FERPA is technology neutral. Doesn't matter if it's a paper towel, on your phone, on Slack. If it's directly related and it's maintained, it's an educational record subject to FERPA. We will caution you that the reason that breaches are happening in great numbers on your campuses and across the country is that people are not being careful with what they're putting in emails. It is always best not to put educational records that is being maintained, such as a grade, in an email. Put it in a shared drive that you give access to the other individual at your institution or the student to go get to. But it's grabbing the wrong email address, sending it out to the whole class. This is where these infractions are happening. So in 1974, the creators of FERPA had no idea what an email was, we assure you. So don't focus on that. Focus on, could you defend that the right people are getting access that they should? And are you using behaviors that could potentially compromise yourself and the student by being shared in the wrong way to the wrong people? Great question. Are medical records part of the educational record and covered by FERPA if they were collected in association with athletes? Great question.
So if they're created in conjunction with athletes and
athletics, I guess, yeah.
Athletics,
yeah.
Who's collecting them? Are they being collected by the is it coming from a medical provider to the institution health center, for example, and they're maintaining them? There's an exception in FERPA to that broad definition of education records that if it's a medical or treatment record, it's not going to be at the post-secondary level. It's different at the elementary, secondary, but at the post-secondary level, if it's only shared with other treatment providers, it's not going to be an education record. But if it's shared with sounds like it may be the case here with the athletic department, then it's going to be an education record. Has to be, in order not to be, it can only be shared with other treatment providers. So if it gets shared with accommodations office or risk assessment team or anyone of athletics, anywhere it might get shared, which has to be done in conjunction with FERPA, but as long as it is, then that simply turns it into education record. It doesn't, you're not prohibited from doing that. But now you have education records instead of something that meets the medical record exception.
I had a delicate conversation years ago with an athletic director who made the assumption that educational records only had to do with what happens in the classroom. And I had to convince them that if it's directly related to student maintain, it is under FERPA. And I reminded that person that in Las Vegas, there are lots of bookies that would love to have access to these because the health and well-being of a football player, for instance, can have an impact on their results with betting. So it's super important that you always realize it doesn't matter where it is in your institution. Education records go well beyond that associated with the class or the classroom we're teaching. So good question. Here's a neat one. We are a Google school. We've heard recently that Google will soon be requiring parents of minors using certain Google items to provide consent, YouTube and some other Google items. This applies to all students under the age of 18. Does FERPA have any bearing on this?
Well, it is, the parents can't give consent if it's a student, a post-secondary student. It would have to be the student giving consent. And you can't have a requirement that someone sign away their FERPA rights in order to get a service. So if that's how you're providing emails, for example, then you couldn't require the student to sign away their FERPA rights in order to get their email access at your institution.
I think if I saw this, I would get our information technology folks in the same room as our legal counsel and have that careful conversation, getting to what LeRoy just said, because you can't override FERPA because of the tool that the records are on. So
and
yeah,
you always have to, this is a good reminder that vendors can create FERPA violations just as anyone else at the institution could, because your vendor and the institution is responsible for its vendors. So if you have a vendor who is requiring or permitting something that's in violation of FERPA, it's the institution that's going to be responsible there, and that's who the department would investigate, not the vendor. You are responsible for your vendors. That's why, again, when I'm on college campuses, one of the things we talk about is what I call the FERPA liability, which is you got to protect the records and you got to give the student access to them, and that you don't want to end up in a situation where someone else is controlling what happened with those, like a vendor, for example, what happens with those records, and that any vendor product that you're considering at your institution, what I advise is have 2 offices at a minimum see any of those contracts. One is the registrar's office and the other is your general counsel. You need FERPA eyes on these contracts, because I've never talked to a vendor provider who didn't say they were FERPA compliant.
Yep.
As I say, some of them actually are. So you really have to be very cautious when you deal with vendors. So if you look at a Google contract, you're going to see things in there that are potentials for creating violations for you. It's actually, if you look in the AACRAO FERPA guide, it's the University of Washington contract with Google that I put in there.
Oh, really? How fun.
Yeah, and I actually got it through, that was one of those open records requests that I got a general counsel of another institution to request it, because there was some Google contracts out there where they had solved the issue, but Google had prohibited the school from sharing that contract. So in the case of, and those were private schools. So in this case, University of Washington's a public institution. So if you look in that one of the appendices in the 2012 AACRAO FERPA guide is on contracting. Yep.
We have a few questions, so I'm gonna jump in here because I want to tell a tale of horror that I went through 2 weeks ago briefly. I pride myself as being a fairly strong FERPA person, and I train on it. Put a hold on a student for violating our registration and tampering and abuse, where they were using information to create ways for students to buy and sell classes. Not allowed. Put a hold on the student. The student took to LinkedIn and Reddit, and thousands of students jumped on board, clamoring that what happened to him was not allowed and was awful. None of it was true. It was a very hard place for me to be as a university registrar, because I could not defend myself without violating the students' FERPA rights. But fortunately, the student contacted a major publication who contacted our media relations to do an interview, and we were able to thread the needle by having the information in the press release talk about what we do in these circumstances that wasn't related to this student. And that went out to all the press releases, and everyone found out the truth. So I just want you to know that it was a painful place to be. I was being attacked personally, but you still have to uphold FERPA, even if the person is doing something that's unethical or not okay. But again, in these delicate situations, as we're talking about here, whether you have university or institutional counsel or you hire out, don't go it alone, because if I didn't have our general counsel reading that press release, I could have still had some problems, and we were able to navigate through that. So even someone as seasoned as myself had to sit there and be very careful to make sure I didn't violate this person's right, even though they were publicly shaming me. So that's my story for the day.
I want to piggyback on that one, because of this was something when I was at the department where this very issue came up, where and it'll come up a lot for institutions. A lot of institutions have these kind of things where something happens on campus, and the student or students involved may tell one story to the press when in fact you know the real answer, and you've got the documentation for what really transpired or why it transpired. But you are as Helen pointed out, you've got an issue there because disclosing that is that's from education records. But one of the things you can do in that instance, and this is what we worked with some institutions on doing this in these similar circumstances, is when you get the press inquiry, is you tell them, well, FERPA prohibits me from giving you that information from the student's education records without a consent from the student. So I'm going to provide you with the consent form, and you can take that to the student and get them to sign it, bring it to us, and we'll provide you that information. And then you can, if you are so inclined, you could say, my guess is the student's not going to want to sign that because they're not going to want me to be able to tell you the truth on all of this. So all of that you can do. You have no FERPA issue there. You are being very prescriptive in the way you would handle disclosures like that. But you put it back on the student and you do it and put the pressure on them.
Yeah, it's just a whole new generation right now of individuals that are not hesitant to go to the court of public opinion, social media. But just remember, as emotionally as it got for me, I had to, more than anything else, oddly enough, preserve that student's FERPA right. So thank you for letting me interject that. Okay, we've got 4 questions here, and we're doing great. It's 11:36. We've noticed an increase in family members attending meetings on campus with students. If the student has a FERPA release on file stating the individual with them has access to all records and correspondence related to their record, is there anything additional that should be done prior to the meeting as a best practice, such as confirming with the student that they are okay with us discussing the record in the context of meeting with the individual present?
I mean, that's more of a preference on how you want to do that from a customer service standpoint with your students. You would not have to do anything else as long as you've got the consent on file. The student can always come along and revoke it, but if they haven't done that, then you know, have that out during the conversation, and then you can talk about anything.
But we can tell you horror stories where the student thinks you're going to talk about their bill and getting a refund, and all of a sudden you need to say, well, you have a hold because you cheated and you're going through the student code of conduct, and then the student gets mad that we said that in front of the family member. So I am pretty darn fervent not to have family members there unless the student needs an accommodation or someone there, because you run that risk. But the best thing to do is to isolate out the student ahead of time to say, I know you're coming to talk about this. It's great you want to have a support person in the Zoom or in person, but we can't control what might come up during this conversation because we don't know what would happen. Just know you're taking that risk. So, yeah.
But in that instance, still the student, you would need a consent from the student in order not to be able to disclose certain things from the student's education record. So it's very important that if they do bring someone along, parent or others, that you get a consent from the student, even though the student might be coming in, again, as Helen said, to talk about their bill, and it morphs into something else. You just never know that. So you want to protect the institution in the upfront.
And I'll just remind you that just because you have a consent from the student to release something, that is a may, that is not a must. The only person that you have to provide educational records and you have 45 days is the student, unless you're responding to a legally issued, subpoena or action like that. So be really careful about these global, anyone can talk to anyone, language such as all records and correspondence. And also I guide our advisors and faculty that there is no follow-up conversation alone with the parent where the parent can write and clarify what happened in the meeting. Each interaction needs a fresh release of consent from the student at our institution to share any educational records outside of that, because it can get pretty slippery. Okay. Are you aware of any exception to the signed writing requirement for consent, Some think assigned writing is not required if the student parent is physically present with them, such as if they're both meeting with an academic advisor.
Yeah,
did-
that's what we just answered, really,
Yeah.
that it doesn't, there's signed consent and there's exception to signed consent. There's not an implied consent in FERPA. So you have to, if you're going to meet with the parents, with the advisor, for example, there should be a consent in order to disclose information from education records, anything beyond directory information.
Great. These are some great questions, some we've not had in the past. Here's one. What is the school's responsibility to inform the Department of Education of a FERPA violation by one of its employees?
Yeah, so there's not a requirement that you do that, but informing them could be helpful if there was a complaint lodged and an investigation. So if you, and institutions would do this when I was at the department, so we would advise them, if you know there was a FERPA violation and you're taking action. So if Helen sees, uncovers a FERPA violation, she's going to be on it, and she's going to deal with or the party or parties that created the violation, and there's going to be action taken. There's going to be documentation made on that. That's where you could use that as your basis for saying, this happened with this student. Here's the action we took to deal with that, and tell the department. And then if they get a complaint from that student, for example, it's going to be a quick investigation because they already know that here's the action you've taken in that regard.
One of the things that I had thought I had heard LeRoy say all these years, and he did not, that I learned when I came to the University of Washington, which has 3 campuses and 65,000 students, we have about 5 to 10 breaches a month where people are accidentally releasing information they shouldn't. I thought it was required under FERPA that not only did you have to record the incident in the student's record, but that you were required to tell the students. And I learned that there is no notification requirement in the law. It's a best practice depending on the circumstance. So I encourage you to go to that part of the law, which LeRoy can probably quote for you, and make sure you're very clear on what your obligations are in the remediation process in terms of the recordation, and because that's what's going to protect you, that if the Department of Education comes a calling, and they usually don't write or email, they call, you want to be able to go to those records and say, yep, we knew it, we remediated it. You can put in there if you provided training to those that did it or that you notified, but you at least have to make record of it so that that is proof that the department knows that you did something about it.
And the recordation requirement that's there goes beyond, it simply says that if you disclose information from education records, you've got to record that. It doesn't distinguish between disclosures that were appropriate versus disclosures that weren't appropriate. It says any disclosure, and then it lists the exceptions that are there. So you got to sign consent. You don't have to record that. If it's to the student, you don't have to record that. If it's to a school official with legitimate educational interest, those kinds of things, you don't have to record. Directory information, disclosures, all of those. But in those instances where it was something that was inappropriate, and if it was to a school official who didn't have a legitimate educational interest, then that would need to be documented. That would need to be in the student's record. So while what Helen said is that you don't have to notify the student, you have to put it in their record so that they want to see who's had access to my education records, that shows up there.
Exactly. Yep. Okay, 2 more questions here. Many advising offices use advising sheets to document a student's remaining requirements. It's a physical piece of paper that the student takes with them. If the form is not scanned or maintained by the college, then it's not an education record, correct? There was a thought that we should be scanning the forms into the system.
So the form is something the student fills out. And then what does the institution do with it?
The student appears to walk away with it. So they have an advising sheet. It's a physical piece of paper the student takes with them. So the school official
Yeah.
is filling this out. They walk away. That piece of paper that is no longer with the advisor, so it's not being maintained and it's
Right.
just off wherever the student is. That's not an educational record, correct? That's what the
Right.
person's asking.
And you
Okay.
don't, and you have no requirement that you make a copy of it. FERPA never requires that you create records. It simply says if you create them, then you got to protect them and give the student access to them.
Exactly. Okay. What about an alumni's family reaches out because the alumni passed away and they wish to know what classes they took? Is this covered under FERPA?
What FERPA would say, and this is based on common law, FERPA doesn't address it directly. The department has addressed it. We did this years ago, but just to say that based on common law, that rights expire with the individual. So if it's at the post-secondary level and the student is deceased, then FERPA would no longer apply. If it's at the elementary secondary level and the student's deceased, FERPA still applies because the right wasn't with the student, it was with the parents. So that's the operation of it.
Yeah, we have this a lot. Our records coordinator deals with this quite often, and we just gently ask the requester to prove proof of death of the
Right.
alumni. If it's 150 years ago, we're probably going to assume they're not still with us, but we don't take any chances. We get lots of requests for, oh, I want to surprise grandpa at his 60th birthday for, that he actually graduated. Doesn't matter, or, I want to have it at the funeral. You still want to make sure you're taking good care. That the person is actually deceased if you're going to use that part of FERPA.
Right. Just again, based on common law, if the individual is deceased, but you need to, as Helen said, you would want some kind of documentation on that.
Yep.
And you also need to keep in mind, I actually was at a function in Florida after the Virginia Tech tragedy, and I talked about the fact that I'd gotten a phone call at the department the day after that, wanting to know what information they could disclose on the deceased students, including Joe. And I said, if they're deceased, it's post-secondary. Based on common law, those records are no longer protected. This conference was in Florida. Afterwards, an attorney there struck up a conversation with me and said, just so you know that in Florida, those records would still be protected, and that's because of state law. So that harkens back to what I said early on in this time, that you can have state law that affords greater protection. So you want to be aware of that in those instances where that might apply.
So here's an interesting twist to that. What if a deceased student was taking classes as a dual enrolled student while still in high school? The person doesn't go on to say what their question is, but it's perhaps when they're both in K-12 and your institution, what do you do with revealing records in that situation?
Right. At the post-secondary level, again, it wouldn't apply at the elementary, secondary. At the secondary level, it would, those would still be protected. But you're part of that as a post-secondary institution. You don't need to think about the secondary school. You're just dealing with your records.
Yep. So, LeRoy, we have a first, which we've reached the end of the questions. That's never happened to us here. Usually they're just going on forever. So I'm going to introduce one that's a little tricky that people might relate to. Our provost office hired a third-party company consultants to survey students about why they're leaving the institution. And so my boss asked me to provide information through our academic data management team to them. They were asking for information that we would not release, things like Pell Grant eligibility or their financial aid. But there is pressure because our executive office hired them to do that. What kind of advice might you give when we might be feeling pressure from those above us to provide information we wouldn't otherwise do, or is there any kind of guidelines if someone is doing a study as a contracted entity that would allow us to share what we wouldn't normally share?
Yeah, so there's one of the exceptions in FERPA is for studies done for and behalf of the institution. So one of the 9931 exceptions to signed consent, if someone's doing something for you that you can, you have to have a written agreement with them. That written agreement needs to clarify that they can't, what they can do and can't do with that information, that they can't walk away with it in personally identifiable form at the end of the study, for example. But you could give them access to certain information in as a part of that, as far as from a FERPA perspective. But again, got to have that written agreement. You have to have that control over it. This is one of the places where you would have to record that in the student's record if you gave it in personally identifiable form. And the other thing you would want to think of is if they're wanting information about, from Pell Grant standpoint and that sort of thing, you've got to think about the whole FSA requirements and whether you can share that information under those circumstances or not. So you not only have FERPA, but you have you would have FSA there, and you quite possibly could have Graham-Leach-Bliley implications. So that's
Right.
financial records. So you
And
with
yeah, and
financial
our
records,
direct,
you gotta be particularly careful.
our director of student financial aid, who's a just longtime national expert, holds tight to the Department of Education regulations that information related to financial aid is to only be used in the creation and dissemination of financial aid, because it's very common for outsiders and professors and researchers to want to have details on our students' financial aid status, and we can't. And I think that's what you were referring to, that you have
Yeah.
to always make sure there aren't any complementary laws that aren't necessarily against FERPA that could also prevent you from doing that, and you can stand behind that to say no.
Right.
Yep. Okay. Any, well, we just have a few minutes left here, but are there any, obviously right now you're answering phones about what to do about people landing on campus and wanting to have information on those that they might want to find that we might have information on. Any other hot topics or things that we might hear about at AACRAO or that are coming up with FERPA to be keeping our eyes out for that you're working on, LeRoy?
I'll just mention, I mean, in terms of, I don't have anything to add in that regard other than what I've already talked about on what we're working on here at AACRAO. But the other piece would just be, you know, the availability of campus training for your institution through AACRAO FERPA Consulting. So that's always out there as a an option and a service through AACRAO.
And there are a group of FERPA aficionados, I am one of them, that are working with AACRAO to really think about how we can still absolutely have you tap into the services that LeRoy provides through the consulting in terms of training, but how we can get more trainers at the annual meetings, regional meetings, state meetings, but creating a process by which you go through some kind of training to be a trainer. The 6 or 7 of us that consider ourselves kind of experts just fell into this, but no one has ever audited how well we know this. But LeRoy has done a great job of being in all kinds of places, but I'm really thrilled that AACRAO is working with us to talk about how do you make sure that the trainers know what they know and are certified, and likewise, could we offer even more opportunities for those of you that are members to go through some kind of training beyond like Reg 101 to be able to show that you've got some FERPA expertise, because LeRoy's been pretty amazing all these years to be all places and all things, but we want to make sure that we're getting this information out far and wide. So we hope that this was helpful. If you're able to come out here to Seattle for the annual meeting, can't wait to have you here end of March, beginning April. It'll be beautiful at our brand new convention center. But please do take our guidance, our counsel, no pun intended. Do not go it alone right now without legal counsel when it comes to the more delicate, burgeoning changes and issues that are coming up now. So, all right. Well, thank you so much. Thank you, Belma. We'll turn it back
Thank
over
you
to
all.
you. Thanks, LeRoy.
You're very welcome. Thank you so much for joining, everyone. Thank you, LeRoy. Thank you, Helen. And we will hopefully see everybody again in a few months. More information
Fantastic.
will be on the website that I just shared, along with hopefully our recording of today's webinar. All right. Have a good one. Have a
Fantastic.
good one,
Thank you for
everyone.
having us. Take care, all. Thank you. Bye-bye.
Bye.